Maskun, and a very good morning to all the students from Hasanuddin University in Makassar. I see Khairul Nisa is there. Good to see you again, Nisa. Ya, harap-harap semuanya baik-baik di rumah ya. And to each and every one of you, I think when it comes to this particular subject or topic in international environmental law, it's something which is, I think all of you must have heard in one way or another of this environmental impact assessment. And to start this lecture, actually I've given Dr. Maskun a quiz for all of you to take, yeah, to see whether, I'm sure you're going to pass with flying colors, but just to give you and to see where you are when it comes to this question of environmental impact assessment. So Dr. Maskun, have you actually given them the link to the...
Yes, of course. And also this morning, I already provide in this room, actually, the link in the chat room, actually. So
okay, good.
all the participants, if they are able to connect them and then...
yes. Yeah, they're pretty easy questions, basic questions. There are only 6 of them, right? So are you actually doing them now? Are they actually doing them now? Because let me check my... Hang on, yeah. Hang on, let me just check my email.
Bapak Ibu, teman-teman semua, I'm sorry, I using
bahasa. It's fine. No
I put it, saya ada kirim Google Form-nya di menu chat, so tolong diisi kalau ini.
Oh,
ya, karena itu pertanyaan.
I already see 48 responses so far. Oh. Wow, very good, very good, very good. Like I said, Dr. Maskun, they passed with flying colors. Yeah. Afterwards, I shall share with you their responses. Would you like to see them now, or would you like to see them later?
No, it's okay. It doesn't matter. It really depends on you, Hanim.
Okay. Right. I think what we can do is we leave it in in a suspense mode, right? But don't worry, all of you have answered all the questions, more or less correctly, Dr. Maskun. I'm very happy with that. At least I know that you know what EIA is all about, at least at the basic point of view. Yeah. But now I'm going into the issue, or rather the concept of EIA at the international law level, right? So I shall begin with my PowerPoint presentation. Let me just share it with you. Hang on, yeah. Okay, can you see this?
Yes.
Okay, I can't see myself. Hang on, yeah. I can't see it. Hang on, yeah. I just need to put this down. Okay. Right, so I'll be speaking on environmental impact assessment, or it's known as EIA, to many of the countries here in the world. And at certain regional levels, they have not only EIA, I'm sure you already know this, but they also have some other ways of measuring the impact assessment apart from EIA. And this you can actually find in the European Union. They also have another one which is called strategic environmental assessment alongside EIA, which is conducted at national level. So let me just carry on a little bit with the focus of this lecture for today. We are actually looking at the requirements for EIA from different aspects. The first one will be from the non-binding international instruments, that what we have at the global level. When I say non-binding international instruments, I think, as you all know, non-binding means if the country were to ratify a certain agreement as such at the international level, solely concentrating on EIA or any other aspect, yeah, on environmental environmental um, environmental activities, yeah, or impacts thereof, yeah, it may not necessarily be an agreement that binds you, meaning if it were to, if let's say Indonesia has not conformed to certain provisions within that international agreement, you will not be asked to comply, or you will not be, you know, penalized for not adhering to certain provisions in that particular international agreement. So that's why it is known as non-binding, as opposed to a binding international instrument. I think you all know this basic this basic understanding of non-binding and binding, yeah, agreements. The other one that we're looking at would be a little bit on the, touching a little bit on the international and regional treaties, what we have right now when it comes to EIA. And at last, we are going to move on a little bit to the procedures applied by multilateral development, such as the World Bank here, for example. Perhaps Dr. Masko and even ADB might just have their requirements to carry out EIA in their projects, in their projects that they undertake with other parts of the countries, other countries in the world. And I'll be also touching a little bit on what we have here in Malaysia when it comes to imposing this condition of EIA in our country, yeah. What we have within our legislation, what does it impose us on, yeah, for the project proponents. And also this question about public participation, which is very crucial when it comes to this issue of EIA, implementation of EIA in each country or in each project that you intend to undertake. So let's just begin a little bit on the emergence of EIA. Now, I think you must have read. Are you all learners of environmental law? Are these your students, Dr. Maskun?
Actually, because environmental law is a compulsory
Oh,
in
compulsory.
so that's why they have a background even
Oh,
in
good, good, good. So in other words, we can go even deeper into this, yeah?
yeah.
So when you talk about emergency EIA at the global level, you'll be always referring back to the infamous 1972 Stockholm Conference. You know, every single concept when it comes, or policies, or you know, this punca kuasa, they call it in Bahasa Melayu, yeah, this authority on environmental law, we always refer back to the 1972 Stockholm Conference. So it is no different when it comes to the EIA concept, which which the United States had actually come up with their own. They've established their own EIA law, and that has become the first EIA law in the world. And you can read them. Yeah, it's quite a document where you can actually refer to, and it's known as the 1969 National Environmental Policy Act, which embeds this EIA concept. So you can take a look at that, yeah. And obviously it appears in many domestic state laws. And I know that in Indonesia, you know, you have your own EIA law, which is embedded in the number 4 Management Protection Act, I think, Maskun.
Exactly.
Yeah. Yeah. And even in Malaysia, we have it in our own, which is embedded in our Section 34A of the Environmental Quality Act. And you'll be able to do a research on your own on this, because it's quite interesting to see the comparative laws that we have. Probably in Indonesia, you know, your approach to implementation of EIA may be slightly different from ours. But mind you, when you go into the crux of the concept of EIA in each country, it comes back to the same kind of factors that you have to take into account. So we have something in common, but the manner in which each country or each regional area approaches this EIA may be slightly different somewhat or other. So we'll take a look a little bit on that, on how laws or legislations or international agreements have this kind of a hold on how each country takes takes this EIA to be implemented in their own country. So we shall take a look at one particular case, which is the number one case when it comes to the importance of EIA, and also the contribution by the international courts by coming up, and saying that, stating that, look, we upheld this, or rather we uphold this concept of EIA. Yeah, I will go into the intricacies of this EIA soon. And the next one that we look into is that the technique, what are the techniques combining environmental considerations into socio-economic development and decision-making process? Because it is pretty much a practical approach. Yeah, you have to do, it's a hands-on approach. When you do this EIA, right, first and foremost, I think in Indonesia itself, you would have experts, you would have registered experts to do this EIA. In Malaysia, we have them as well. You need to go through a course to become an EIA expert or EIA analyst, and after which only you can, go through or address a particular project and come up with a report on EIA. So when you talk about a report, as you know, it will be in a form of written statement. And Indonesia, I'm sure, and in Malaysia as well, it is a long process of, identifying, of analyzing, of investigating, in ensuring that EIA concepts are taken into account when all these investigators and analysts of EIA, for them to come up with a report, a form of written statement. So this is actually very important when it comes to documentation. When you're proposing a project, for instance, in your new, well, you're building your new capital city, the one that Dr. Maskun actually, given as a lecture on last year. And I'm sure that the EIA process will be so arduous, Dr. Maskun. It will take a long time, and a lot of people and a lot of factors will have to be taken into consideration, especially when that area is, you have to kind of diminish and demolish and, cut off certain trees and all that. I'm sure it's going to affect a certain part of the environment in some ways or another. So, okay, so as you know, when we talk about the written statement, I think many of you, I hope, have seen this written statement, the documents, basically documents for the decision makers to make in order to ensure that all the information that has been taken down by the analysts or the reporters of the EIA will be taken into account in a serious manner, in which that they would have to understand. When I say about decision makers, basically we are talking about the person who's actually coming out with the development. Yeah, for example, let's say Dr. Maskun, you are intending to build a new block of study learning center, for example, next to Faculty of Law in Hasanuddin. Yeah, and you are the project proponent, right? And you would need to come up with an EIA report. Now, obviously, he would need to ask all the analysts and from your own Department of Environment in Indonesia, in Makassar, for example, to come up with an information on environmental consequences of that particular building of that center. So just to make sure that, you have all the impacts that will be affecting, whether it's social impacts, health impacts, environmental impacts. If you were to see the diagram down here, all these things will need to be taken into account, because any kind of building of things, changing in the landscape, changing a certain structure in the community will definitely affect any one of those, or many of this, or all of this that you see on this diagram. You're talking about the social impacts in the community. You're talking about the impacts on the hearing, for example. If there's too much building going on, tractors and all this running around of lorries and stuff, definitely will affect the quality of the community surrounding, or circling that proposed activity. And then you were talking about health impacts, you're talking about pollution of the air, you're talking about pollution of the water. On wildlife, for example, if you're cutting down trees, obviously, or jungle, or forests, definitely there'll be an impact on wildlife. The wildlife will just run away, and then you'll be losing your, your biodiversity values in your country, and that is utmost important when it comes to coming up with a decision on that particular activity. Obviously, impacts on water, impacts on land and air, and the cultural impacts, including economic impacts, will also need to be taken into account when you are coming up with this EIA. So your decisions, Dr. Maskun, for example, as the proposed proponent to build that center must, or rather, should be influenced by that kind of information given by the EIA analysts or investigators, by that written report. Yeah. And at the end of it all, this is the most important thing, which I feel that many project proponents have actually, I don't want to say failed, but more or less have not taken into serious regard on public participation. This public participation is an issue, is an ongoing issue, even in Malaysia, whereby, for example, there are logging trees in certain parts of Pahang or up north in Kelantan, and for that purpose, there are many community, what we call them indigenous communities surrounding that area, have been affected by those activities, and they have not been taken into account when they are, when there are these activities of cutting down trees, logging. So at the end of the day, this public participation is being mocked by some of the other stakeholders. Yeah. So before we get into the next slide, I wish to show you a little bit on the basic understanding of EIA by linking this YouTube for you to watch. It's a 5 minutes YouTube video. Dr. Maskun, I'll just click on this here. I hope it'll get us to the...
Okay.
Can you see this?
No, Hanim.
Can you hear? Can you
We
hear?
can hear. Yes, we can hear, but we can see the...
Can you watch?
No, we can watch it.
Can you watch? Can you see anything?
No, Hanim, still your presentation actually. We can watch it.
Okay, hang on.
Yes.
Hang on. Hang on. Try it again. Hang on. I just stopped this. Okay, I'll screen this. Hang on. Can you see this?
Yes.
Okay.
Imagine that the local council has decided that they want to build a new factory. And there's obviously quite a lot of things to be taken into consideration before giving the project the green light. An environmental impact assessment provides decision makers with the information in order to consider the environmental impact of a project. It should inform the decision-making process. So when is it needed? Well, for example, this factory that we've just discussed, but other projects might include building a new airport, dams, reservoirs, large housing projects. All sorts of big projects might require an environmental impact assessment. Quite a lot goes into one of these things, and there are several stages in the process. First is screening, and this is there to determine whether or not an environmental impact assessment is needed at all. Next is scoping. Scoping is a way of deciding which impacts need to be assessed, and that's going to vary depending on the project and the location. A baseline study, this is a way of collecting data on the current state of the area, the current situation that we're in. For example, you can't predict the effects on local plant species if you don't know which plants are already present or in what sort of numbers. We might take into consideration physical factors such as the geology, the topography, biological things like animals and plant species present, socioeconomic factors, and also cultural factors. Now, obviously, you might argue that socioeconomic and cultural factors are not strictly the environment, but they are relevant to creating one of these reports, and they are often included. Next is the impact prediction. So if we do go ahead with this project, what are the possible consequences? And of course, leading on from that is the mitigation. If we've established what the possible negative consequences are, how could they be reduced or how could they be prevented? Also, are there any alternatives? So could we redesign the project slightly so that we could then remove these problems? And lastly, there should be adequate monitoring and assessment. During and after the project, there should be monitoring of the environmental conditions, which may be continuously changing as the project continues. And then, of course, assessment of the impacts of the project. The last thing is a non-technical summary. Basically, once this full report, this full assessment has been produced, it needs to be presented in a way that non-specialists can understand. And so that's what a non-technical summary is for. There's a lot of criticisms of EIAs. They're obviously not perfect. Of course, the first one is sometimes the advice can be ignored. If perfect advice is given on how to reduce the impact, who's to say that that has to be followed? Next, the reports may be limited in scope, meaning all of the potential negative impacts may not have been identified in the first instance. Baseline studies may be incomplete. There might be lack of available data, or basically the people who collected the information may not be as knowledgeable about the situation as they need to be. And there's often a lack of monitoring and review. So basically, once the project gets underway, the negative consequences that develop throughout the project are not always investigated, not always addressed. Let's look at a possible exam question on this. You might get asked.
Okay, I shall just stop right there because it's more on building exams. But as you can see, that would be the basic understanding of EIA. I think all of the countries share more or less the same, the same approach on how to address or to carry out this EIA process. Let's just carry on with. I hope I hope all of you have received a little bit of understanding. But I'm sure that because all of you have already got background in EIA, what it's all about. I think it is just something which, just to for you to recollect on the EIA processes. Yeah. Okay, so the definition of EIA, I think, as you know, would be a systematic, which is very important. When you go back to that particular slides, yeah, remember the way that you approach the steps that you need to handle. It has to be in that particular approach. Yeah, it has to be systematic. Number 1, number 2, number 3, and so forth. Scoping, screening, and things like that. So you need to follow very carefully the stages of carrying out EIA, and it has to be integrative. Integrative means very simple. All the stakeholders have to be involved, or else there are many. And I think one of the criticisms where the YouTuber has already mentioned that at the end of it all, it may not even be a comprehensive report on the impacts of the likelihood of carrying out that particular project. So it has to be holistic, integrative, yeah, and considering possible impacts, because at the end of it all, you must remember, EIA is not done during the middle of or towards the end of the activity. It has to be carried out at the early planning stages. So you must kind of sit down and figure out, what are the possible impacts on the environment or on the cultural, social impacts and so forth, for a decision to be made by the project proponent on how to mitigate and prevent environmental pollution or impact thereof. Yeah. So basically, the objective of EIA is not to force decision makers. Somehow I wish they could force decision makers, Dr. Maskun, because at the end of it all, also, some of these project proponents that was mentioned before, again, by the YouTuber, may not even take this seriously. And they may just put it aside, cast the written statement of the EIA aside, and at the end of it all, they just carry out to their women fancy. So again, this objective EIA is, I hate to say this, not to force decision makers, yeah, but at least to adopt the least environmentally damaging alternative, yeah, but rather to make explicit the environmental impact of the development so that the environment is taken into account in decision making. So that's very, very important, because most of the project proponents feel that the environment is not important. By having this EIA, it only tells them that it is utterly important, most important for them to take into account when building whatever projects, whatever, you know, institutions that they wish to build. So it's very important. Now, at the end, when it comes to this EIA, it will, in a way, avoid backdoor or behind closed door process during decision making. Again, this is very difficult to comment. It depends on the government, you know, on the local authorities, on the state agencies, you know, on how they carry out such decision making. So it has to be transparent to a certain extent. If it's not transparent, then we have all this, you know, behind, oh, I scratch your back, you scratch mine, I give you, all this corruption will come in. Yeah, and that has always is one of those problems when it comes to really putting down EIA as a strict implementation process. This is one of the ways, yeah, and placing EIA requirements in the legislation is not a foolproof plan, because as we all know, yeah, legislation sometimes can be kind of bent. It reflects on the communities, on the, you know, society's way of thinking as well. You know, if you need it fast, and there could be some kind of, you know, this backpedaling. So it's very important that we take this EIA process very seriously. Again, which project needs EIA? This one, I think all of you should know. Yeah, before looking at which project that requires EIA, is worth looking at the environmental change that needs to be considered to provide the context. First and foremost, like I've mentioned just now, Dr. Mazkun, you're building a center, yeah, or it could be anything, yeah, under our Section 34A of the Environmental Quality Act, we refer to our own rules and regulations specifically on EIA projects. So we have a list, you know, listing down 19 projects that says or requires EIA. I'm not sure in Indonesia whether you have that particular list. Do you, Dr. Maskun, in Indonesia? That states, you know, this, if you're building an airport, if you're building a ferry terminal.
Yeah, I think so. Yeah.
Yeah. So I think that's a good, I think that's a good a study to carry out, Dr. Maskun. I think in terms of comparative law between Indonesia and Malaysia, it is worth looking at that, you know, especially in on the issue of public participation. So moving back to this, yeah. So you have to figure out, let's say you are somebody who intends to build something, right? Okay, so you start by thinking what you wish to build. Secondly, as a responsible person in the society, yeah, despite the fact that you are carrying out the project, you will need to come up with some kind of an idea. What would be the consequences to the environmental condition in that surrounding area that you've chosen to build that project? So I've listed 4, and if you were to see at number 4, I say state others, right? So in your mind, or you can write down now as to what do you think, apart from the 4 environmental consequences that you would take into account when you are coming up with a project. Let's say you're an environmental student, which you are now, yeah, and you've been asked, or you're an advisor to the project proponent, the one who's going to build it, to look at all the environmental change that you think will crop up when that project proponent builds, you know, builds whatever that he wishes to build. So if you can write down a little bit, have an idea, then we'll see what it's all about. Yeah, but you must understand that EIA is required for all projects that have been identified within your legislation as likely to have a significant effect upon the environment. So the word significant is very important. What do you mean by the word significant? I think I've mentioned that in my last lecture. Yeah, you must have an adverse effect on the environment. What do you mean by adverse impact, significant impact? I mentioned that during my last lecture. Okay, so if you've not already known, so these are the things or rather the areas which you need to look at, and you can call them as environment valued resources. So if you were to see, it ranges from socioeconomic activities right down to climate. Yeah, so apart from those that was mentioned before, yeah, you can look into all of this, perhaps more. Yeah, perhaps more, because things change. You know, environment conditions changes over time due to certain influences. So these environmental value resources may also change. So these are kind of examples I can give you, you know, ranging from socioeconomic activities, community health and safety, noise pollution, agriculture like pollution, terrestrial ecology and biodiversity, marine ecology and biodiversity, geomorphology and landscape, groundwater quality, surface water quality, river water quality, air quality and climate. Now, if you were to take this into heart, you'll be able to see that there are many areas of law that you can somehow, if you're affected by it, for example, noise pollution, it causes nuisance, yeah? You may be able to come up with a lawsuit against the project proponent. So it depends again, if you're affected by any one of this as an individual or as a whole community in that area, you may be able to take an action against that project proponent. Okay, so now we'll be going into the principles underlining EIA that has been addressed at the international level, yeah, and that basically two types of principles. You have to look at EIA as something which allows the project proponent to be cautioned by at the earliest level, at the earliest stage, where that kind of activity that he's undertaking may raise some harm, yeah, to human health or the environment, and such precautionary measures should be taken even if some cause-effect relationship are not fully established scientifically. For example, if let's say Dr. Maskun is building that particular center next to Hasanuddin, yeah, and Dr. Maskun, well, not Dr. Maskun, perhaps the investigators, yeah, find that there is some consequence that may be impacting, let's say, for example, may be impacting the littlest impact to the community who lives 2 miles away from the university. For example, I know it's, you know, when you were to see 2 miles, oh, you know, I don't think it will happen. But if let's say it can happen, you know, even though you have not fully established it scientifically, there is no kind of results on whether it is fully infecting the community 2 kilometers down the road. But then again, this principle of precautionary approach must be taken into harm. Even if you cannot establish there is, you cannot confirm that those people living down the road will be harmed by your activity, you still must take some measure to mitigate it, to prevent it. Okay, so this is very important, these precautionary principles. And I think we have to read under international environmental law. You can read on, you know, this will give you a huge idea on what you mean by this principle. The next principle is on polluter pay principle. I think in our legislations we have that, yeah? If you pollute, if you carry out a certain activity that will harm and cause environmental threat, then you are asked to pay. So this is clear cut. So here it says, where the party responsible for producing pollution should also be responsible for damages done to the environment. So this one you'll be able to see in so many facets of the community, you know, where the manufacturers themselves will need to pay. Of course, the society and the community such as us will need to pay if you were to pollute. So these are the two principles by which the EIA has stemmed from or embedded within, if you were to see later on in international agreements, that these kind of principles are being raised, yeah, are being given adequate attention, that these are two most important principles when it comes to EIA. So the guiding principles of environmental impact assessment, there are a few. The first one, again, like I mentioned before, public participation is of utmost importance. So there must be some adequate participation of all stakeholders. There have been issues on what you mean by adequate participation, yeah? And this you can find in many scholarly articles, you know, but it never really confirms what you mean by adequate participation, apart from the fact that there must be some kind of a representation from the community, representation from the NGOs, representation from the legislators, from the state agencies, from local agencies, authorities, and so forth. So there must be quite a holistic approach in coming up with this written statement in the form of EIA. Next one is transparency. Transparency, again, it must, as like I've earlier mentioned in my earlier slide, that, you know, without this EIA, people can just carry out activities willy-nilly. In other words, you know, they can just, like this corruption somehow will come into play, and it will cause a lot of non-transparency throughout the building of certain activities. So this is one of the guiding principles. You need to be transparent at every stage of the investigation to come up with the EIA. And this must be clearly understood by all participants, meaning from local authorities, from the project proponent. I know, you know, for example, Dr. Masco may want to build it within 3 months, but obviously you can't. Yeah, so there must be transparency, again, that must be carried out by the project proponent and also all the others towards the affected community. The other one is certainty. The process should have clear objectives, consistent, and be conducted within agreed time frame. So again, if let's say Dr. Maskon wishes to have that carried out within 3 months, obviously, you know, it has to be conducted within a agreed time frame, but taking into account as well, some investigation may take longer than most, yeah, probably because of the magnitude of the activity. And also, you know, in certain cases, local authorities may be a little bit slower here and there, and they will take a lot of time and they don't have enough equipment, and they need to get people, outsource people from overseas to come and become EIA consultants and things like that. So it may take a little bit more time, but it must be agreed by all stakeholders. It has to end within, let's say, 3 to 6 months. Yeah, because the project proponent too must be treated fairly, because they have a certain amount of time and certain amount of money. So, you know, all these things must be laid out on the table. Next is to come up with some kind of a decision that has some kind of value, integrity, meaning it is based on the best available information there is at that moment, and all relevant factors need to be taken into account by decision makers, meaning at that time, during the investigation analysis, all available documents, whatnot, you know, all the information that you can get on that particular activity, particular area, the surrounding areas, you know, what will be impacted and things, and all those things that needs to be factored in, you must take into account so that it gives some kind of a legitimacy to that decisions made in the after reading the EIA report. So it has to be something which is certain, but obviously sometimes, like I've mentioned before, impacts can be uncertain. But at the end, you know, you should rely on some kind of a sound risk assessment and management. And that's why you need consultants, expert consultants on this. The next guiding principle is cost effectiveness. Now, the process should meet its objectives while imposing the least cost to participants. That means, again, Dr. Maskon only has 1 bilion rupiah. Banyak ke Dr. Maskun? I'm not sure whether banyak ke ataupun 3 billion or 4 billion to come up with the, but at the same time, he doesn't have, he has all there is, 3 billion. And the money that is to be paid for this EIA must be borne by Dr. Maskun. So obviously it has to be some kind of cost, it must be carried out effectively and looking into the cost, the best cost or the least cost paid by Dr. Maskun. Yeah. Next is practicality. Now, the process should recognize community concerns, commercial realities, best practice technology, and scientific uncertainties. Now, sometimes people tend to be overboard. So they forget about the practicality or the realities of things, what's happening at that moment in time, which is, again, need to take into account the practicality of coming up with or conducting the investigation. You must realize that there are certain limitations, certain constraints. You may not have the best practice technology in that area, but you may perhaps have good technology to figure out certain harm coming up from that certain place. But you need to pay, for example, half of your expenditure to bring in that technology. Obviously, it's not practical. Yeah, obviously it's not practical. And then certain things that you may ask the public or the community surrounding them to move away, again, that may not be practical. So at the end of the day, you would have to ensure that all these guiding principles are taken into account and making sure that all stakeholders needs to be accountable to what has been stated in that particular report. This takes, again, responsibility by the government to provide clear and detailed reasons in the EIA report to all stakeholders. Basically, you're telling Dr. Maskun as a project proponent, this is the condition after we've investigated. Again, to the community or to the, to the when you're talking about animals that are being affected, probably to the Department of Wildlife, for example. So everybody has to be on board and everybody has to take accountability. They have to be in it, take responsibility. And again, it doesn't mean that when you have an EIA report, there is no flexibility. There must be some kind of flexibility. There must be some kind of a give and take as well, but within a certain limitation, So at the end of the EIA report, be able to see the recommendations on how or what are the processes that can replace certain things. They may not give you one or two solutions, they give you various solutions in order to ensure that particular activity can provide some kind of a protection to each and every one of those that are affected. So it gives a little bit of, give and take here and there. If Dr. Maskun can't do this, probably, there's another solution to this, and it has to be accepted by the social community, for example, and that will be the process until you come up with the right recommendation to ensure that at the end of the day, the activity is undertaken by Dr. Maskun will not harm, try as it may, will not harm or prevent or reduce harm to the environment and as well as to the community surrounding that particular activity. So let's look into the international environmental law as where we can find this EIA endorsed by the international community. So this you can find under Principle 17 of Rio Declaration, where it says EIA as a national instrument shall be undertaken in proposed activities that are likely to have a significant adverse impact on the environment and are subject to a decision of a competent national authority. So it says here, the principle that has to be at, kind of influence, the judgment of a certain country, when there is a proposed activities, that would likely to have some impact on the environment when conducting that activity. That's one. So there must be a national instrument. So in Malaysia, we have the Environmental Quality Act 1974. In Indonesia, like Dr. Maskun was saying, you have it under the Environmental Management Act 1992, I think. I'm not sure, Dr. Maskun, 1992, is it?
Actually, the Management Act is 2009, number
Oh,
2.
2009, yeah, 2009. So, you know, you must have a national instrument, that dictates the requirement of EIA, and that has to be carried out when there is some activities that are likely to have significant impact on the environment. And thirdly, you must have a competent national authority to carry out this implementation of EIA. In Malaysia, we have Department of Environment, and in Indonesia, you have your Bapedal, right?
Yes.
Yeah, you have that. Yeah. So this is important. Now, to what extent the international community has taken this into heart? You'll be able to see, I think you're able to Google even there's so many websites now that gives you an indication of how many countries have actually implemented EIE. Yeah, and definitely there are more than 100 right now. So for those of you who have answered more than 100 as true, then one up for you. Yeah, in the quiz, I've actually asked that question. So again, Principle 17 of Rio Declaration, you'll find it adhering to Principle 21 of Stockholm Declaration. Okay, so it has to go in line with the Stockholm Declaration. Now, under international environmental law, there are a few cases requiring EIA. If you were to see, I've already put up 5, but I would like to highlight this case known as Pulp Mills case in 2010. Now, last lecture which I had, I've raised this case as well, but this particular case is very close to the heart of endorsing EIA at the international level. Yeah, this is the first case at the International Courts of Justice where they have deliberated a lot on this requirement of EIA, especially when there are two countries, are crossing each other's paths when it comes to EIA implementation, whether they've done it the correct way, have they conformed to EIA in accordance with their legislations or their regional or their bilateral treaties and so forth. So let's take a look at this. Yeah, Argentina, as you know, is next to Uruguay, and they're sharing a river, and that river is actually River Uruguay. The case is surrounding this construction of wood pulp mill in Uruguay. So what happened was there is obviously some activity, processes within the mill, and effluent has been discharged into the River Uruguay, which forms the border with Argentina. Very clear cut, yeah. So meaning, for example, let's say, for example, Malaysia is right next to Makassar, for example. We're sharing a river, we're sharing a river or a bay. And suddenly, Malaysia, as an example, has discharged whatever effluent or, that causes pollution into the air, pollution into water, and that would affect, obviously, Makassar. So the obligation in this particular case is for them to carry out an EIA. And the human aspects when it comes to this case is they look at it very seriously, whereby they had a public consultation. Public consultation where they invited the residents of the affected state in Argentina, and they were asked to give some kind of a feedback on what needs to be done or what can be done, how have they been affected, and so forth. So they brought this case to international court in 2010. And again, like I've mentioned just now, this is the most significant authority on EIA in general international law. Whether or not, the question is whether or not the EIA is a treaty-based obligation. Is it a domestic-based obligation? Or is it a general international law? Or is it a part of customary international law? So this came about in this this particular questions or issues were raised at the International Court of Justice. When you look at this scenario between Uruguay and Argentina, yeah, so they had already a statute between them, but there was no reference to EIA in the 1975 statute of the River Uruguay, nor there was any applicable law in the dispute, nor are Argentina or Uruguay parties to the ESPO Convention on Transboundary Impact Assessment. There was none. Okay, there was none. It was completely silent, this reference to EIA. So what Uruguay has done was that, okay, even though there was no requirement of EIA, they actually carried out an EIA process. And if you were to see what I've written here, they had a company, and 2 further EIAs were produced by consultants acting for the IFC, which funded the construction work. So basically, Uruguay had carried out this EIA, despite the fact that there was no reference to EIA that needs to be made by Uruguay as a project proponent. So this case was referred to ICJ, and ICJ referred to Vienna Convention on Treaties. They were questioning on the issue of whether this is a treaty issue or whether this is considered as general customary international law, this EIA, right? So they referred to this Article 31, which says, and it was reflecting Principle 17 of the Rio Declaration on Environment and Development, and it also reflected the EXPO Convention, and also Article 7 on ILC draft articles on transboundary harm. So ICJ placed all these principles, convention, and articles as a basis for their decision. So when they looked at Vienna Convention, it says the obligation to protect and preserve under Article 41 of the statute, interpreted in accordance with the practice, and in recent years has gained so much acceptance that states now be considered a requirement. I've highlighted this in orange, a requirement under general international law to undertake an environmental impact assessment where there is a risk that the proposed industrial activity may have a significant adverse impact in a transboundary context, in particular a shared resource. So basically, this paragraph, which I've highlighted in orange, actually reflects Principle 17, Rio Declaration, the ESPO Convention, and also Article 7 of the ILC draft articles. Now, if you were to go back again to my previous lecture on responsibility and liability, then you can trace this back to the Trail Smelter case. It goes back to that again. Yeah, but it has not been this general acceptance that EIA is a general customary international law. Not then. But with this case, there's already an impetus, a triggering effect on the fact on this issue of EIA as an imposition under international customary law. Whether it is customary, you don't need treaties, you don't need legislation, but it is a customary international. Everybody does it. So this is kind of a starting point of that, this case of the pulp mills. And if you were to move on, I've also mentioned here due diligence and the duty of vigilance and prevention. And again, when you talk about all these three, due diligence and the duty of vigilance and prevention, monitoring is another process which needs to be embedded within this due diligence, duty of vigilance and prevention, monitoring. Because usually, like what the YouTuber was saying, and it's quite rightly so, after after everything has been done, the institution by Dr. Musk has been built, the after effects of the development needs to be looked into also, because it will take some time, right? For example, the land to settle, the soil to settle, the building to settle. There could even be some, at that moment in time, after the building has been built, there could be an extra environmental harm that you may not have assessed prior at the early on stage during the investigation of EIA. So there must be some kind of monitoring continuously carried out even after that project has been built. So this is again the crux of the pulp mills case. So the court has now confirmed that in appropriate circumstances, an EIA must be carried out before to the implementation of a project that is likely to cause significant transboundary harm. You see, when you see the word likely, right? Likely means, oh, it can happen, it may not happen. But again, you go back to the precautionary principle, it doesn't matter. As long as you think there could be some kind of a harm or threat or risk to the environment, you just put it within the EIA as one of those areas that you need to be careful about. So, moreover, it also helped that once operations have started and where necessary throughout the life of the project, it says here again, continuous monitoring must be undertaken. So in its Mills judgment, the court noted that it is for each state to determine in its domestic legislation or in the authorization process for the project, the specific content of the environmental impact assessment required in each case, having regard to the nature and magnitude of the proposed development and its likely adverse impact on the environment, as well as to the need to exercise due diligence in conducting such an assessment. Here, the court has confirmed that each country must come up with its own domestic legislation, which we have, Dr. Maskun. Malaysia, Indonesia and Malaysia, we have our own domestic legislation addressing EIA. And within that legislation, we must have specific content on how it is supposed to be carried out. We have that, Dr. Maskun, right? We have that. We have our regulatory board or regulatory agency in the form of Bapedal and Department of Environment in Malaysia to carry out or to make sure that this is carried out in accordance with our domestic legislation. So international law requires at a minimum that an EIA assess possible effects on people, property, and the environment of other states likely to be affected. So this was within the judgment of the court. So again, it endorses the fact that EIA is part of, well, beginning to be a customary international law. This is the first case, yeah? So if national law does not ensure that such an assessment is carried out for whatever reason, then there is inevitably a breach of the obligation to do a transboundary EIA. Again here, transparency is important, integrity is important. How that needs to be done in each country, then there should be an independent body to see whether or not, for example, DOE is carrying out its job to ensure that EIA is implemented effectively. It depends. It depends on each. I'm not sure in Indonesia how it's done. Yeah, but in Malaysia we only have Department of Environment. We don't have an independent body to monitor, to monitor the processes of EIA carried out by DOE. Perhaps we should have that. We should have that. Because sometimes, some of the processes have not been adhered to, especially when it comes to public participation. And that always been manipulated by either the project proponent, or sometimes the courts are not with this public participation, or the country itself does not have this passion for this participation amongst the society. So it's very difficult. And the society remain silent or be silent, or at whatever stage their participation or their inclusion in the processes is not been taken into account. So there could be some problems here and there. EIA approving authorities. The process employed for carrying out an EIA is not set out in any international instrument. So if you were to see in international agreements and so forth, even in the ESPO agreement, they may have an independent body, but to carry out that particular EIA processes, it depends on the country. Some states rely on the operator or developer to carry out the EIA. This is dangerous. This is dangerous. When, let's say, for example, let's say Dr. Maskun, it's in your interest to have a good EIA report in order to build your building, your institution, your new building, new building for learning. if you were to carry out the EIA, there could be subjected to some kind of a manipulation, because it is your interest, it is in your interest to make sure that your project is carried out. So obviously, that has been a real contention in Malaysia, you know, whereby the developer, you know, I pay you to come up with the EIA report, yeah, but you know, I want my project to be carried out, even though I know there'll be some environmental consequences caused by my building of that structure. But since I'm paying you, you know, there could be a real hanky-panky here and there. And that again relates to corruption. And that is one of the usual comments given by many scholars, many researchers reports here that corruption is somehow undermining this process of EIA. So you have to be very careful. Now, what if national laws do not provide for EIA? What if there is none? Now, this I would leave to all of you students, yeah, to find out of those more than 100 has EIA, yeah, but what if some of the countries in the world do not have EIA? What happens then? First and foremost, my dear students, do make a research on countries that do not have EIA. That's the first thing. Secondly is that how do they carry out EIA if they have none embedded within any legislation in their country? So you can take a look at Southern Bluefin Tuna Provisional Measures 1999 to answer this question. Land Reclamation Provisional Measures 2003 to answer this question. But the usual method is to apply to international courts, especially when there are, you know, regional concerns, bilateral concerns. Take a look at this. This is actually a question that I'd like you to look into. Read on your own. If national laws do not provide for EIA, what happens? But what if an EIA has been carried out? How far, if at all, is it open to challenge in an international court? For example, Dr. Maskun and I, we have, okay, Dr. Maskun, you are the president of Indonesia, I'm the prime minister of Malaysia, right? And there is a dispute between us about the usage of river, you know, that borders our countries. So how do we, okay, I'm carrying out the EIA and you're not happy with it, right? And you say that, oh, because of this, well, I'm not happy with it. I disagree with the EIA report. Now, what happens? The question is whether or not we can bring it to the higher courts. Obviously, in domestic courts, it doesn't work because this is a battle between two countries, two nations. So we have to bring it to ICJ with the approval from both countries, of course. So the question is, can an international court review the adequacy of an EIA that was posed by, in this case, pulp mills dispute? That's the question. In both cases, and also the MOX plant, I want you to look into this as well. I won't deliberate too much on the MOX plant. Now, but these both cases, the treaty that was applied was silent about what is required in an EIA. It doesn't say anything. It just says, okay, you need to come up with an environmental impact assessment, but that's it, full stop. It doesn't say that you need to follow scoping, screening, all the procedures that I know. It is not detailed. As you know, in many of the regional treaties, international treaties, they do not lay out detailed or specific procedures or methods on how to carry out an EIA. It just tells you, you know, these are the things that you should have, you know, you should have this, and this, but the actual practicality of carrying it out, it's always silent. It's really up to the domestic countries, domestic legislation. So let's go back again to this question of Argentina and Uruguay. So in pulp mills, bear in mind, yeah, EIA was carried out by Uruguay, yeah. Argentina is opposing. Argentina is opposing to obviously Uruguay's choice of EIA, yeah. So Argentina's advocates devoted a great deal of energy to pointing out alleged inadequacies, mistakes, and flaws in the various environmental assessments carried out on the Botnia proposal. Remember, they carried out like 2 or 3 EIA assessments, EIA reports. So they argued that key issues were ignored in the EIA, in particular the choice of alternative sites. Remember, when you talk about coming up with some kind of a plan for EIA, you need to be flexible. So there must be some kind of a replacement to certain choices. Yeah, there could be choice 1. If you're not happy with this option 1, you can go to option 2 and option 3. So they argued that those kind of things were ignored in the EIA carried out by Uruguay. So they appeared to be inviting the court to hold that both the Botnia EIA and the IFC EIA were insufficient and did not sustain the decision to authorize the plant. So they were saying that, you know, what Uruguay has done is not good enough. So they were clearly, this is the thing, Dr. Masko, that I meant. You know, if you are the project proponent, you are the ones who are appointing investigators or consultants of your own, out of your own pocket money to come up with IA. So this is the key issue that can actually be raised by the other party. It looks as though that, you know, it's not independent. Yeah, somehow it is done, you know, having some kind of influence by that party that's paying you. So this is the problem in Argentina and Uruguay case. So Uruguay responded that the relevant question is whether the assessments actually undertaken provided evidence on which it was unreasonable to base the decisions. Okay, basically what they're trying to say is this. Uruguay says, you know, what we've done, basically, we've done all right. You know, we've taken everything. We took into respect the impact on the river, into Argentina. You know, the EIA is not required to assess risks that are too remote, meaning, you know, you can't even comprehend that it can happen, or it's merely speculative. So they were conducting IA on their own merits, on what they feel, Uruguay feels is the correct measure or is the correct method to carry out in order to complete the EIA report. So the EIA in its final form, as approved by DINEMA, covered the possible transboundary impact of the Botnia plant, the river's flow characteristics, air pollution, etc., and alternative sites. So they did do this. The EIA in its final form, you know, did consider all of these factors, right? But at the end of the day, Uruguay, Argentina says it's not good enough. And Uruguay argued that its environment agency, DINAMA, had been duly diligent. Remember, we go back to the principles of due diligence and so forth. And they have taken all matters into account before EIA, into an EIA report. Finally, the court decided that Uruguay had in fact assessed other sites. It accepted Uruguay's arguments based on the ILC commentary, which is on transboundary harm, that the scope and content of an EIA are not specified by general international law. Meaning, what it tells you really is this. Look, under international law, it doesn't dictate each country to come up on the method or practices of EIA. It doesn't. It leaves those decisions with the country itself or the countries themselves. And here it also says it is for each party to determine on a case-by-case basis what is required having regard to the nature and magnitude of the proposed development and its likely adverse impact. There you go. It tells you the court has decided that, you know, it's on a case-to-case basis. You do what you think is right, looking at that particular activity, at that particular situation. You know, it depends on you. Uruguay, Malaysia, Indonesia, it depends on you. So the court found nothing wrong with the EIA undertaken by Uruguay, apart from the failure to make timely notification to Argentina as required by the statute which they have had between Argentina and Uruguay on that river Uruguay. Yeah? Besides, it was found that there was no pollution. That makes it even worse. And for you to compare this decision with, you can take a look at Japan, yeah, measures affecting the import of apples, where in this particular case, the issue of EIA must be sufficiently adequate. So the issue here that I would like all students to look into is what is the meaning of sufficiently adequate. Okay, so those will be, that particular part is on case laws. Yeah. Now we're looking into non-binding instruments, which I've mentioned again here and there on ILC draft articles on prevention of transboundary harm, specifically to Article 7, which also raises issue about environmental impact assessment. So these are the non-binding instruments, which means, you know, countries may not take this into heart, yeah, by imposing such within their legislation. Treaties and other binding instruments. Okay, so these are the treaties or other international instruments, international agreements that has a reflection of EIA within it. Obviously, the European Community Directive on EIA 1985, and on ESPO Convention, which we'll look at a little bit of a video. Yeah, hold on. And then we have on the Protocol on Environmental Protection to the Antarctic Treaty, Nordic Environmental Protection Convention, the UNEP Regional Seas Convention, NUMIA Convention, the UNCLOS, ASEAN Agreement. We have that too as well in our ASEAN Agreement, and also Climate Change Convention. Okay, I think I've spoken quite enough. Let's just move on a little bit to a video on YouTube again on what is, you know, a ESPO Convention. Can you see this? Can you see this?
Yes.
Yeah,
Yes.
you can. Yeah, okay, I'll start from the beginning. Okay, thank you.
I'm sorry, Professor, we could see the video, but unfortunately we couldn't hear the audio.
Sorry. I'm sorry.
We could see the video, but we cannot
Yeah,
hear the audio.
okay, let me just try again. Yeah, let me just try again.
Thank you, Professor.
Okay, okay, hold on. Yeah, let me just try again. Can you hear it? No?
Yes.
Can you?
Industrial and infrastructure
Yes.
development
Yes.
projects benefit communities and create
Yes.
economic opportunities for current and future generations. To ensure that such projects are also environmentally sustainable before authorizing them, most countries use environmental impact assessment, or in short, EIA. Making EIA transboundary benefits people and nature beyond national borders. Under general international law, all countries must undertake an EIA of their planned activities that risk significantly damaging the environment of other countries. In line with the precautionary approach and the principle of prevention, this must be done early on in the planning process. The leading international agreement that governs transboundary EIA procedures is the Convention on Environmental Impact Assessment in the Transboundary Context, also called the ESPO Convention. Adopted in 1991 and in force since 1997, the Convention has parties in the United Nations Economic Commission for Europe region, including the European Union. The Convention is being opened for accession to all United Nations member states. The ESPO Convention applies to proposed activities that are likely to cause significant adverse transboundary environmental impact in such diverse fields as energy, transport, industry, mining, waste management, water management, agriculture, and forestry. Common examples include power plants and cross-border infrastructure projects. Aside from protecting the environment, the Convention has helped countries improve their environmental governance through enhanced transparency and consultation of authorities and the public in planning and decision-making. Better informed and better accepted decisions have helped avoid costly mistakes. Countries have benefited from strengthened international cooperation on environmental assessment, which, in turn, has helped prevent later misunderstandings and potential disputes. The ESPO Convention offers a framework and procedures for countries that are contracting parties to discuss their planned activities and to address likely environmental damage before it occurs. The Convention guides the countries through the key stages of the transboundary EIA. A country that plans an activity listed in Appendix 1 of the Convention, say, to construct a motorway, a thermal or nuclear power plant, or a large dam, must first determine if transboundary assessment is needed, and if that is the case, it must notify as early as possible the affected country or countries of the project. The affected country indicates whether it wishes to participate in the assessment. If it does, the two countries will exchange relevant information. Their public are provided equivalent opportunities to participate throughout the process. The country of origin must complete and share with the affected country EIA documentation containing information on the project, possible alternatives, environmental impacts and mitigation measures. The countries then enter into consultations on the documentation, for example, on alternatives and mitigation measures. At the end of the process, the decision makers of the country of origin consider the results of the assessment, the consultations and public participation before taking a final decision on the project, say, to authorize the construction of the motorway, the power plant or the dam, and inform the affected country and its public of this decision and its reasons. After its start, the countries may also decide to monitor together the activity's impacts. A solid system for transboundary EIA helps countries safeguard the environment and green their economies. It can also help in achieving the Sustainable Development Goals. UNECE assists countries in introducing and effectively implementing the transboundary EIA procedure. UNECE serves as a secretariat to both the ESPO Convention and its Protocol on Strategic Environmental Assessment. The protocol intervenes earlier in decision-making and benefits the soundness of government plans, programs, and sometimes even policies and legislation. Due to a long-standing support from the European Union, in cooperation with UNECE, several countries in Eastern Europe and the Caucasus took legal and practical measures for applying the Convention and its protocol. Currently, policy dialogue and technical cooperation continues as part of the EU for Environment programme.
Okay, so as you can see, yeah, ESPO Convention is one international agreement that specifically deals with environmental impact assessment. In Indonesia, Dr. Maskun, I'm not sure whether, I don't think any of the ASEAN countries are members to the ESPO convention. I doubt it lah. I doubt it. Yeah, this is more concentrated to the northern states, not to the southern states. Yeah. But I'm not sure lah, whether or not ASEAN should come up with something like this, especially with the case on transboundary air pollution, whether there could be a requirement of EIA among states to have a session on EIA, especially when there's, lately we have not been getting transboundary air pollution. Yeah, everything has been well for the past 1.5 years. What if there is an activity that may raise this issue on transboundary air pollution again, whether there should be an EIA requirement on the part of that particular country? So at the ASEAN level, obviously we have none. Yeah, although there is a statement in the ASEAN agreement, but we have not taken it to heart. Perhaps, with the plastics pollution issue, which Dr. Masko and I are looking at right now, probably and affecting the marine areas, this could be an issue that we can raise, Dr. Maskun.
Yeah.
It depends. Let's see how it goes. Yeah. But when you talk about treaties and other binding instruments in regard to EIA, yeah, these are those instruments that we can take heed. And at the International Development Bank, all the banks, they also have their own EIA requirements. So this is my last slide. And perhaps you may want to look into this YouTube. I will provide the presentation slides to Dr. Maskun. Yeah, if you'd like to review my slides again, by all means, and take a look at this YouTube. And if you are still interested in, looking or viewing the other YouTubes, by all means. But even banks have their own requirements on EIA. This is what I'm saying. Yeah. To what extent, I'm not so sure. Yeah, because I've never looked into that part of the world when it comes to this, especially when it comes to banks. We always talk about treaties, non-binding instruments among states, legislations, what have you. But when it comes to financial institutions, well, this is actually my first time learning about this. Probably there's something that we can all look into. And that's the end of my lecture for today, everybody. If you have any questions, kindly you can ask me now, or if you do not have any, you can always forward it later. But I'd like to share with you the results on your Google, on your quiz. Let me just check it out, yeah. Okay, can you see it now? Okay, there are 56 responses. Yeah, thank you very much for taking time to answer only 6 questions. So I shall stop accepting responses now. A little bit of insights, yeah, out of all the questions, you were to see the average point is 4.13 out of 6. Median is 4 out of 6 points. So the range is basically 1 to 6. So the total points will be 6, yeah. So average point would be 4.13. Frequently missed questions. What is essential in EIA? Correct responses out of 56, there are 21. An example of an EIA stakeholder is select all that apply. So out of 56, there are 12 correct responses. EIA is defined as, so here we have 48 out of 56 correct responses. A process of, if you have, gone through my slides, I think right now, for those who have opted for the second and the third one, probably, it should have been the first one, right? So out of 48, so that's very good. A process of identifying, predicting, evaluating the likely impacts of a proposed project or development to define mitigation actions to reduce negative impacts and to provide positive contributions to the natural environment and well-being. So that is the correct answer. So kudos to those who have chosen the first option. More than 100 countries have a EIA. So there are 50 of you have opted for true. Very good. Yeah. Now in this regard, do make a small research on EIA, you know, to see what are those countries and whether those countries have actually come up with their own EIA reports. Really, I mean, some countries have come up with their own legislation and so forth. Whether or not they have in true form, you know, come up with their EIA, that's another thing, Dr. Maskun. You know, you can have beautiful legislations. Whether you implement or enforce them is another thing. So perhaps, my dear students, you can take a look at this. What are those countries and what are those countries who have not got this EIA process? Yeah, take a look at those. It'll be interesting. And why? The question is why they have not, why they don't have an EIA process in their country. That's the question. Why? What is essential in an EIA? Select all that apply. So 21 out of 56 correct responses. Actually, this is a trick question, Dr. Maskun. Select all that apply, actually all. Yeah, the answer is actually all. All three options are correct. So it allows decision makers to assess the project's impacts in all its phases. Yeah, very important. That it allows the public and other stakeholders to present their views. That it contributes to improve the project design, so that environmental and socioeconomic measures are core parts of it. So these three are the correct answers. Yeah. EIA should be done. 46 out of 55 correct responses, Dr. Maskun. Very good. Early in the project planning process, very, very early on. Yeah, this is a giveaway question actually. So not once the development has begun, everything must be done before. That means you prep before you do anything. Yeah, even going into lectures, Dr. Maskun, I think both you and I, we prepare, you know, everything before we carry out the class. So everything must be prepared very early, at a very early stage. An example of EIA stakeholder is select all that apply. This is another trick question again, Mr. Dr. Maskun. Select all that apply. So 12 out of 56 correct responses. I think, I hope that many of you, after what we have gone through today, that you would know that every stakeholder, ranging from project proponents, community, regulators, NGOs, and there could be more. There could be more. You know, we must get together and actually talk about this or come up with a more reliable, more, how to call this, an EIA which has an integrity, legitimacy, that's the word. It has legitimacy, whereby we know that each one of these players are important in coming up with a proper EIA report. Okay, and the final one is, oh, this is very good. This one I think everybody should know. Yeah, Indonesia's EIA process is known as AMDAL. So this is a dead giveaway question again. So very good. Well done to each and every one of you. For those of you who have gotten less than what you wish for, probably you might just like to take a look at it, you know, read more about EIA. You know, you may not know now, but if you were to carry on doing your research and do a lot of reading of EIA, then you understand, you know, it's basically, it's very simple, Dr. Maskun. It's just that you need to prepare before anything bad comes into play, anything bad happens, right? So you must make sure that you have everything all ready in order for you to mitigate certain things. So, good responses, Dr. Maskun, and thank you very much for, you know, giving the link to your students. And that's it for my lecture this morning, Dr. Maskun. It's if there are any questions that you wish to pose, by all means, but if you don't have it now, I've got some chats here. Oh, thank you so much. Okay, Wahyudin, ada panggilan kerja. Okay, no problem. Thank you very much for coming. Yeah,
Hanim,
and yes.
sorry, Hanim, to
Yes.
interrupt you. Actually, after the enactment, the law number 11 2020 omnibus law in Indonesia, actually there are some changes in the idea of the AMDAL actually. But the most important thing is I couldn't say anything because it's still too earlier because it's enacted in August 2020 and then the governmental degree up February to in February 2021. So we would like to see in the future how the idea of AMDAL actually in Indonesia will be work in like what you already explained, because there are some changes. The idea before the previous law, the law number 32 2009 and the omnibus law, because there are some changes in it. So that's why probably I'm not sure also, but I will see in the end of this year actually how the omnibus law work, especially in the idea of AMDAL. I just would like to give you an example of it. In the previous law, in the previous law number 32 2009, AMDAL become the AMDAL document become the basis for determining environmental feasibility decision. But when the omnibus law come, the AMDAL, the documents is the basis for the environmental feasibility test of a business activity. It means the businessman can started their project even the AMDAL is not released by the government officially. So it's a little bit in my point of view, it's a little bit dangerous actually for the environment, because the businessmen can started their activity.
Can start the activity.
Yeah. While the AMDAL,
that's no good.
So that's we were still waiting how the governmental regulation work, because it's too earlier to to examine, because it started in February in 2021. So just I just give you the development of AMDAL in Indonesia after the enactment of the law 11 2020 about Cipta Kerja in Indonesia.
I think on my personal view, that is, somehow I think Indonesia, with that, if that is what Indonesia intends to do, allowing businesses to proceed with their activity before EIA is taken place, I think it's a step backward, isn't it?
Yeah.
I mean, at least for me, that is for me.
So that's also actually that's brings some a little bit worry for all, especially for some NGOs, and then the the environmental defenders, like but we will see, because we have to discuss and analyze more about the governmental regulation actually on the environmental aspect, because we would like to see it more and deeply analysis actually, especially regarding to the AMDAL, because some some protests and then some criticism coming to the law actually, because the problem about the AMDAL. That's it. Yeah.
Two questions. The first one is, if let's say AMDAL has changed to be in that kind of a way, whereby businesses are allowed to carry out their activities before any kind of environmental impact assessment is carried out, I hope that the government has put in place some kind of measure by which the businesses place some kind of they are placed under some kind of restrictions, to carry out those activities. I know EIA is not being applied as that at that time, but I just hope that your government places some kind of a scrutiny measure, mitigation measure, or some kind of a strict compliance for the businesses to follow if they were to carry out that kind of thing. And there must be, and going back to Rafika's question, when you talk about independent body, this is where I think Rafika, independent body should come in. There must be a centralized or independent body, like cannot be centralized one, independent body, probably professionals, engineers, engineering board, environmental board, the independent one, NGOs that would come into play. If this thing were to carry out, yeah, it would have a disastrous consequences, because businesses do not know unless unless the government says, hey, look, the government does not have any resources anymore to carry out EIA. I do not know the reason as to why they come up with AMDA. Possibly, you can talk to me later about this, Dr. Maskut. But possibly the reason why they give it to the businesses, or probably we don't have any money anymore to carry out EIA. Bapeda cannot afford to do this anymore because it's very costly, expensive. And therefore, we are giving this responsibility to the businesses to come up with their own kind of EIA. I hope, adhering to your AMDAL, right? Give them some kind of responsibility, but within a certain limited scope of, what I mean? There must be some strict measures that they need to comply with. I do not know. I'm just guessing. And then the other thing is, Ibu Rafika, yes, when it comes to independent body, in Malaysia, at least I can say in Malaysia, yeah, you don't have any. This is the problem, and DOE governs this compliance to EIA. And in hindsight, we should have one independent body, but they have to be independent lah, kan? They cannot have any kind of relationship or some kind of a close or some kind of relationship with the government or things like that. The problem in Malaysia, we tend to have that. If you have an independent body, there could be somebody sitting as the chairman of the independent body that has done work with the government, for example, or has done work for that particular thing. There could be, because you see, environmental, at least in Malaysia, environmental community in Malaysia, we are rather small. We don't have a big one. We don't have a big, government, environmental conscious community here. I hate to say it, but that's what we are. But we are grappling with it. Yeah, we are moving towards it. But having this independent, usually when something happens, then we only call in for independent body, not during the EIA processes. Never. It is always when something happens, when there's soil erosion, when there's air pollution that's happening right now, then only an independent body will be called in. We call it the commission to investigate whatever not. But as it is for EIA, no, we have none, Bu Rafika, which is a shame. I think you're on the right track there. But then again, it goes right to the political situation in the country as well, all this will come in when you talk about independent body. But we have independent body in terms of when you talk about crime. Yes, we do have that, but that's only when something bad really happens. Then we call in for a commission. And the other thing I need to ask you is, I am absolutely ignorant about your omnibus. Can you tell me what this omnibus is? Yeah, because I've been hearing what's omnibus. What does it mean really? Now I'm learning from you. I'm not sure what this is. What is it?
Okay. This is actually there are some laws. There are some laws, and then the government created one laws to dealing with the one issues on it. So, for example, the idea of environmental law. So there are some changes in the article of the previous law, and then in the amend they amend those articles in the omnibus law. So it means there are some changes. Actually, there are some changes. They put it in the how to explain.
That means, for example, Dr. Maskun, if you were to say, when you talk about omnibus, you're talking about all legislations in
Yes,
Indonesia that's been looked at, reviewed.
yeah, that all regulation related to the what we call job creation. That's what we call in Indonesia Cipta Kerja. So this law is refer to more pro to the investment side actually. So everything laws related to the investment should be
Looked
amended
at.
in order to adjust to the idea of the investment. So that's why I'm saying that's the idea of the AMDAL in the previous law. One of the legislation is a kind of like reduction, or I'm not sure. I couldn't say like that one, but I would like what should I do is doing more and more research related to the idea of what you giving a lecture today about the Indonesia, how the talk after, because a little bit the norm is changing actually. The norm of AMDAL is changing, so it should be more and more, deeply research actually in order to do it.
Yeah, but I'm sure it's a lot to do with your investment policy in Indonesia. That's why they're giving a free hand to the businesses to bring in money. Yeah,
Yeah.
foreign money, foreign funds flushing into Indonesia right now. I think that's why they are giving a lot of leeway, flexibility to the businesses. But I think on that note, when it comes to the impact on the environment, they may disregard it.
Yeah.
They may disregard it because, if it's not embedded within their responsibilities, their diligence process,
Yes.
then it's a tough one. It's a tough one. It's a tough one, because you need to balance. This is what you call sustainable development, and you need to balance the development and the environment. Which way are you going? Are you going that way? Are you going this way? So
Actually,
delicate balance.
between businessmen and then the environmental should be walk in the same line actually, not one
Yeah,
dominant than the other. That is the problem.
exactly. Exactly. And this also brings me to another question, my dear students, is, when you talk about a balancing act between sustainable development goals, the development and environment, you need to look at this. This is an opportune time, a fantastic opportunity for all of you to look into the responsibilities and liabilities of businesses to the environment caused by their investment of businesses activities in Indonesia based on human rights principles. Because if they can do as they like, right, Dr. Maskun, they will create a lot of environmental threats and risks in Indonesia. Yeah, not and not, how to say this, and not propagating environmental rights for the social community, then the quality of the environment will just drop.
Yeah.
So this will be a good time for all of you to look into this research, whereby you're placing responsibility and accountability to those businesses in Indonesia, especially when your new change in law in AMDAL has taken place, and placing them the obligation within their corporate social responsibility to look into their activities so that as not to harm the environment. I think this is a good moment for you to do that. Raise that. Bu Rafika, if you're interested in this, I know you're doing a lot on, international law and all this. Perhaps you can work with Dr. Maskun, Dr. Birka, and all my gang over there in Hasanuddin. Work on this. Work on this is very important, because you do not want, just because you have money flowing into the country, you can do as you like. So, and I think Indonesians, you have a lot more passion than the Malaysians. You can go up in all arms, in all of this. Do a moratorium, Dr. Maskun.
Yeah.
Do a moratorium.
Actually, in some area, we do the moratorium, but I'm not sure whether it would be.
Well, it works, yeah. No, well, give it a shot, lah. something to do, something to do.
Yeah, yeah.
You know, but it's a good area to go into lah, you know. And I hope all the best for Indonesia, because I don't know lah, I feel that this is like a step backward lah, my dear. Ayo, it's like we have to go back in circles one more time, you know, just to tell. Yeah, I don't know lah. I think it's also because of COVID-19. People are getting a little bit muddled. Too much staying at home. But anyway, thank you so much, everybody. Yeah,
Thank you so much.
sorry?
Thank you so much.
Thank you. Can we take a photo? Can we take a snap photo? Maskon, please snap a photo of all of us. Can all of you just turn on your video?
Semua ininya. Lulu bisa diambil fotonya nggak, Lulu?
Yes, I can.
Okay.
I have a question actually.
Yes.
I'm so sorry for interrupting, but is it still possible for me to ask a question?
Sure. One final question, a short answer.
One final question.
Yeah.
All right. Yeah, thank you so much for the opportunity. So I would like to ask, because this is a case that currently happening in our province, in one regency. So it is currently happening. So there is a plan to conduct a marble mining activity in one regency, but there are so much wrong things happening during the process of the EIA itself. So first, the project proponent of that marble mining activity only called out representative of impacted community who wants to be paid to sign the local community consent.
Who wants to be, sorry, Nurul, who wants to be?
The impacted community nearby the marble mining activities.
Right.
To consent to sign the consent to perform such activity, despite the fact that they are not informed that such activity could carry out ecological disaster to their own village. And while they're going to perform the activity, the project proponent, they're going to perform it on the body of watersheds, which that watersheds actually provides water to 3 of the regencies. But the project proponent do not consultate to the local authority responsible for the watersheds. There's a second thing that shall be questioned. The third is, while the project proponent keep doing the exploration and disobey and disregard all of those things stated before, they even stated that all of the IEA document is finished and signed till the provincial government, and now they're in the stage of extracting. And one of the local community come into an environmental NGO to report about it, and that environmental NGO came into the local community and educating about the consequences of such activity. The local community then tried to reject the activity, but they cannot do so since they can't even access the information to the EIA. There's no transparency. So my final question is, what is actually the essence of EIA? What is actually the function of EIA if most of guiding principles are disobeyed and ignored? Probably that's buzzing of my head.
Yeah. Right. Oh, this is a very philosophical question, actually. You know, it cannot be just in one sentence. What I have to say is this. I think when it comes to the law itself, right? I've mentioned this many times to Dr. Maskun and to my colleagues. We have beautiful laws, fantastic principles, interesting provisions within our treaties, beautifully crafted, right? But at the end of the day, it goes back to the quality of people that implement all these legislations and treaties. It goes back to the knowledge-based community. It goes back to the integrity of the society. So that has to be resolved first. And at the end of the day, my dear Nurul, there is no one answer to this. There's more questions to your questions. How can we? Why can we? You know, it's been going on for years, for hundreds of years. The questions that you raise has turned out in history, has turned out in case laws. We can never find an answer because The society at large, being in Malaysia, US, Indonesia, or anywhere in the world, it goes back to the knowledge-based community. How passionate are we when it comes to the environment? Are we looking at solely money-making projects? How much are we into this? It goes back to the very definitive of the realities of life. Okay, I've mentioned this during my research or my seminars during my research on transboundary haze pollution. You're talking about survival at the end of it all, aren't we? You're talking about making that few cents to make sure that we live day to day, month to month, year to year. So all those questions, all those issues and concerns are coming into play at a more larger scenario. And in your case, sadly enough, it has to be, in your province, where it's affecting communities, where the businesses are disregarding compliance measures. So what is it that you want? So when you talk about SGD, we can have SGDs, Dr. Maskun, we can have, this, we can have that, we can have this. But how far is it affecting us as a person, as a society, in businesses? Because some businesses, Nurul, they don't care. I hate to say it. They are looking at profits, revenue. That's what they're looking at. When we talk about transboundary haze pollution, when we talk about companies, palm oil companies, yeah, they say they have to go for this roundtable sustainable, palm oil, right? This roundtable. Yeah, they talk about how to mitigate, how to come up with new procedures, methods in order to reduce air pollution, for example. But how far are they truly committed to that? Now, I don't have an answer to that. I can only come up with my responses to this. Yeah, but it is more, you have to search within the soul, I think, of each and every one of us. We cannot just say, hey, look, I am a lecturer in environmental law, so therefore, I recycle every day, that kind of thing. No. It doesn't happen. Sometimes it doesn't happen that way, Dr. Maskun.
Yes.
So it depends, Nurul. I don't have an answer for you. I can, I hope that somehow raises some more questions in your mind on how to make things better. Yeah, but at the end of the day, it has to be a knowledge-based community. Everybody must be at that level. Yeah. Okay, Nurul. Okay, thank you so much, Nurul, for that question.
Take photo, please.
Okay, photo now, please. Thank you.
Photo,
Oh,
please.
11 o'clock already. Yep. Okay. Yang lainnya di mana ya?
Ya, yang lainnya boleh nggak dihidupkan on cam-nya? Ya, yang lainnya dong supaya bisa. Oh ya, Nurul coba, Nurul, can you do it, Nurul?
Okay.
I'm going to count down.
Okay, thank you.
From 3, 2, 1. Okay, we'll give it another shot. 3, 2, 1. All right, that's
okay. Thank you very much, Nurul. Thank you very much, everybody. Take care. Make sure you get your vaccination. Yeah. Thank you, Dr. Maskun.
Okay, thank you, Prof.
Hanim. I'll get in touch with you again.
Okay.
Bye.
Bye.
Assalamualaikum.
Waalaikumsalam.